Okay, let's unpack this because it is absolute poetry in motion.
Oh, it really is. It's incredibly meta.
Right. Imagine you take this massive, just impenetrable court filing and you translate it. You break it down so an everyday audience can actually understand the stakes.
Yeah, you do the heavy lifting for the listener.
Exactly. You hit publish, and then, just 48 hours later, bam, you are hit with this heavy-handed legal demand letter threatening your whole organization.
All over, what, 2 specific words?
2 words. So today we are doing a deep dive into a legal demand letter that is actually regarding a previous deep dive.
Which is just a fascinating look at the hidden gears of media law, honestly.
It really exposes the friction between how normal people speak and how lawyers read. So for you, the listener, we've got a very specific stack of sources today to walk you through.
Right. First up, we have an original transcript from a previous deep dive.
Yeah.
Specifically, that's Season 2, Episode 43.
And then we have the pushback, a June 5th, 2026 legal demand letter from an attorney, James Catterson. He's representing the Liakas Law firm.
And finally, we have the response. That's a June 8th, 2026 letter from Damian Caldwell, who's the president of the iFraud Foundation.
So the mission today is to examine this really delicate legal intersection. We're looking at public court allegations, the boundaries of reporting privilege.
Yeah, which is a huge concept we'll get into.
Right. And how the law handles hyperbole and commentary. We're going to look impartially at how lawyers deconstruct a single line of audio and how publishers defend it.
But, before we really get into the weeds, we definitely need to establish a very strict disclaimer for you right up front.
Yes, very important.
The underlying lawsuit here, AmTrust versus Liakas, it contains unproven allegations. The defendants categorically deny these claims.
Right. They are vigorously contesting them in court as we speak.
Exactly. We are not taking sides here. We are merely exploring the documents provided to understand the anatomy of a media law dispute.
Yeah, that distinction is super critical. We're looking at the mechanics of the conversation, not adjudicating the facts of the actual lawsuit.
So to understand the legal demand, you first have to understand what that original deep dive was actually discussing, right?
Yeah, you need the context. So in that previous session, the hosts were breaking down a civil complaint filed by AmTrust Financial.
And they used this very vivid analogy to describe the plaintiff's claims. They called it a factory.
Right, an assembly line of insurance fraud. The complaint alleged this sprawling, interconnected network.
It had runners finding clients, personal injury lawyers, filing suits, gatekeeper clinics.
Yeah, prescribing treatments, surgeons performing procedures, all of them allegedly working together to just, manufacture mathematically optimized insurance claims.
But the part that triggered this entire legal firestorm centers on the financial engine of that alleged factory.
The money.
Always the money. The dispute comes down to the mechanics of litigation funding.
Right, so the original transcript detailed allegations that vulnerable, often non-English speaking claimants were being targeted.
According to the complaint, these claimants were pushed into unnecessary, highly lucrative spinal fusions just to inflate the insurance claims.
Which is awful, and afterward they were allegedly told they couldn't work while the lawsuit was pending?
Right, and because they had no income, a company called Jumpstart Funding LLC allegedly steps in. They offer them cash advances to survive.
And here is the mechanical detail that really matters. The allegations state that these advances were offered at usurious 50% compounding interest rates.
50%, which is wild.
Let's just pause on that math for a second. If you take an advance to pay your rent while you can't work and your lawsuit takes, say, 3 years to settle.
Yeah, a 50% compounding interest rate means that advance just balloons. It becomes this unpayable mountain of debt.
Exactly. The financial pressure on the claimant would be immense.
Which brings us to the exact moment of contention. If you scroll to the 7.46 mark of that original transcript, the hosts are discussing this specific funding setup.
Right.
The original host notes that AmTrust alleges Jumpstart Funding is actually owned in part by the principals of the Liakas firm itself.
And the other host confirms it. They say, that is the allegation, yes.
And then comes the line. The original host says, quote, "They're quite literally loan sharking their own clients to guarantee they never back out of the scheme," end quote.
Boom. 14 words. They use a colloquial phrase.
Yeah, but because they use the specific words loan sharking.
Which implies a literal criminal statute.
Exactly. The Liakas lawyers saw a legal wedge And they drove that wedge right into a demand letter sent on June 5th.
Because, the legal mind processes language very differently than a general audience does.
Oh, absolutely. The June 5th demand letter from Pillsbury Winthrop Shaw Pittman explicitly isolates that single sentence.
Right. James Catterson, the attorney, he basically argues that the statement is categorically false and defamatory.
His core argument is that the original AmTrust complaint never actually uses the phrase loan sharking.
Or alleges a criminal offense bearing that specific name. But wait, let me stop you there for a second.
Sure.
If the complaint doesn't explicitly allege the crime of loan sharking, aren't the lawyers right? I mean, isn't inventing a criminal charge that doesn't exist in the source document the textbook definition of defamation?
Well, that is the exact tension we need to unpack here. The lawyers base their demand on a very specific legal framework.
Okay, what's the framework?
They cite New York Civil Rights Law Section 74 and a Second Circuit case called Kinsey versus New York Times Co.
So in plain English, what does that mean for publishers?
In plain English, New York law has a specific shield for journalists, podcasters, commentators. It's called reporting privilege.
Right, reporting privilege.
This privilege means you can report on and discuss public court filings without being sued for defamation, even if the allegations in those filings eventually turn out to be completely false.
Because, I mean, if reporters could get sued for just quoting a lawsuit, no one would ever cover the courts.
Exactly. The public wouldn't know what was happening in their own justice system at all.
The privilege exists because the public has a fundamental right to know what's going on.
But think of reporting privilege like a protective fence drawn exactly around the borders of the court document.
Okay, a face.
As long as you stay inside that fence, meaning your summary is a fair and true report of the document, you cannot be sued.
Ah, I see. So the lawyers for Liakas are arguing that the deep dive stepped 1 foot outside that fence.
Exactly. By using the word loan sharking, they argue the publisher crossed the line.
They went from protected reporting of a civil contract dispute into unprotected, defamatory criminal accusation.
Right, because the original complaint talks about high-interest funding loans, structured as advances, and unlawful interest.
It doesn't use the Hollywood mobster term.
No, it doesn't. So the lawyers are essentially saying, you added a crime to the summary, so you lose your shield.
And they use a really fascinating procedural maneuver to demand an immediate fix.
They really do. The demand letter sets a very aggressive timeline of 7 days for a full retraction.
7 days is incredibly fast in legal time.
It is. And to justify the speed, Catterson points out a unique detail. The original publisher, the iFraud Foundation, had previously stated under penalty of perjury in a separate matter that their deep dives can be generated in 5 to 20 minutes.
Oh, wow. That is a brilliant, aggressive move.
Right.
They are using the publisher's own stated technological capabilities against them.
Exactly. They're essentially saying, if your AI or your production team can build this educational audio in 20 minutes, you have zero excuse for needing weeks to issue a correction. Fix it now.
It compresses the traditional timeline for a legal remedy by weaponizing modern generation speeds. It's kind of wild.
It is. But looking at the grievance itself, we really have to examine the defense. Did the deep dive actually step outside that protective fence?
Because honestly, it feels like the lawyers are putting a single brick under a microscope to claim the entire house is structurally flawed.
Right.
They are completely ignoring the rest of the building. So how does the publisher defend against this strict literal reading of 14 words?
Well, this leads us directly into the iFraud Foundation's June 8th response letter.
The pushback.
The foundation, through its president, Damian Caldwell, completely refuses to retract the statement.
Good for them. What's their argument?
Their core defense is exactly what you just pointed out.
Yeah.
Context is everything.
Yeah, you can't just strip 14 words out of a 15-minute discussion.
No, you drop them in a sterile legal vacuum and claim you're defamatory. It just doesn't work that way.
If I remember correctly, the transcript shows they were very careful to frame the entire discussion as a breakdown of unproven claims, right?
Absolutely.
Right.
Caldwell's letter unpacks the audio leading up to that exact line to prove that point.
Right.
A critical detail the lawyers ignored is that immediately prior to the loan sharking comment, the original hosts explicitly stated, AmTrust alleges that Jumpstart funding.
Oh, so they literally said the word alleges right before it.
Yes, and they followed it with, that is the allegation, yes.
Wow.
Furthermore, throughout the entire transcript, they repeatedly stated the enterprise was alleged, they called them allegations in a lawsuit, and expressly noted that the defendants deny the claims.
So the foundation was clearly building the frame of a civil dispute, not like handing down a criminal conviction.
Exactly. They laid the groundwork for the listener that everything being discussed was just one side's claim in a lawsuit.
But what about the word itself, though? How do they justify using loan sharking if it's literally not in the complaint?
Well, the Foundation's core legal defense centers on the idea of contextual hyperbole
Contextual hyperbole.
and protecting commentary. They argue that loan sharking was never presented as a literal criminal adjudication.
It was just a rhetorical device.
Right. It was a hyperbolic characterization of the complaint's actual written allegations.
They took the disclosed facts from the complaint, specifically those allegations of 50% compounding interest rates.
Combined with the alleged ownership overlaps between the law firm and the funding entity.
Right, and they just gave it a descriptive label.
Exactly.
I mean, if you were listening to that, hearing about a 50% compounding interest rate being pushed on vulnerable people who couldn't work, your brain probably makes the exact same leap.
Of course it does.
You don't think the hosts are reading from the penal code? You just recognize they are describing a predatory financial situation using a recognizable shorthand.
And the legal system actually understands that cognitive leap.
Oh, it does?
Yeah. Courts generally recognize that audiences are sophisticated enough to distinguish between a dry, literal recitation of a statute and colorful, rhetorical hyperbole used in commentary.
It's like how we use metaphors in everyday language. You know, if a sports team absolutely dominates another team, a commentator might say they massacred their opponents.
Right.
Nobody listening to the broadcast thinks the commentator is alleging actual, literal homicide.
That'd be ridiculous.
We all understand it's a hyperbolic characterization of a factual event. It's just a very lopsided score.
And the law protects that kind of colorful speech. If commentators were forced to only use the exact, sterile terminology of the source material, public discourse would be entirely unreadable.
It would be so boring, no one would listen.
The Foundation believes the deep dive fairly conveyed the substance of the lawsuit while providing relatable commentary on those really dense financial allegations.
They argue that hyperbole, when it's clearly based on disclosed facts that the audience has just been given, is a fully protected form of speech.
Exactly. And they don't back down an inch in their response.
Yeah.
The letter ends on a very definitive, almost defiant note.
Oh, I love that. How do they wrap it up?
The Foundation ends its letter by reserving all rights, privileges, and protections. They make no admission of error whatsoever regarding the phrase loan sharking.
Wow, they're standing their ground.
Completely. The only commitment they make is to continue their practice of transparency with the audience.
Okay, so they assure the lawyers that future discussions will continue to make clear that the litigation remains contested.
Right, that the defendants vigorously deny the claims, and the matter is entirely unadjudicated.
Essentially, they're telling the lawyers, we will remind people this is just a lawsuit, but we stand firmly by our characterization of the document.
Pretty much. So we have this intense legal standoff.
On one side, the lawyers are demanding a retraction based on a strict, microscopic, literal reading of a single sentence.
And on the other side, the publisher is flatly refusing, citing the protective bubble of surrounding context, reporting privilege, and the legal allowance for hyperbole.
Which brings us to the ultimate question for you, the listener. Why should you care about a legal squabble over 2 words between a New York law firm and a media foundation?
You should care because this dispute highlights a massive ongoing tension regarding your daily media consumption.
It's really about the public's right to understand dense, complex information versus the strict frameworks utilized by lawyers to defend their clients' reputations.
Think about how difficult it is to read a 100-page federal court filing.
It's impossible. It's full of archaic jargon, endless citations, and just impenetrable legal syntax.
Exactly. To the average person, a federal complaint is basically written in a foreign language.
You need a translator to understand what your own legal system is doing.
And the public relies entirely on accessible, conversational commentary to translate those filings. We rely on analogies, metaphors, and, yes, sometimes hyperbole to grasp the sheer scale or severity of an allegation.
Because if publishers are terrified that using a colloquial term like loan sharking to describe a 50% interest rate will result in an immediate crushing defamation lawsuit, it creates a massive chilling effect.
A huge one. If the threat of litigation is that high over a single colorful phrase, journalists and podcasters will just stop translating it.
They will just read the dry text or, honestly, just ignore the story altogether.
It threatens the media's ability to use relatable language. It is fundamentally about your access to information.
If every summary of a public controversy has to be vetted by a legal team to ensure it doesn't deviate a single syllable from the source document, public discourse becomes incredibly constrained.
It leaves the public in the dark about vital civic matters simply because the language required to explain them is just too risky to use.
But, to be fair to the Liakas lawyers, they are arguing the flip side of that coin.
True. In an era where a 15-minute audio summary can be published and shared globally in seconds, defendants deserve protection too.
They are arguing that commentators shouldn't be allowed to escalate a civil contract dispute into a perceived criminal enterprise just for the sake of an entertaining broadcast.
Right, because a careless metaphor can ruin a reputation instantly.
It is a very delicate balancing act. The courts really have to weigh the absolute necessity of a free, expressive press against the real damage that can be done when public figures or businesses are unfairly maligned by loose language.
And what makes this specific case so fascinating is the speed at which this balancing act is now happening.
Which leads me to a final provocative thought for you to mull over. We talked earlier about how the demand letter specifically pointed out that modern educational audio deep dives, exactly like this one, can be generated in 5 to 20 minutes.
Yeah, that is the reality of the modern media landscape.
The speed of synthesizing, analyzing, and publishing complex public information is accelerating to near real time.
Meanwhile, the legal frameworks dealing with defamation, reporting privilege, and the nuances of human speech were built centuries ago.
Right, largely for the era of the printing press and the daily newspaper.
And the law is notoriously slow to adapt to technological shifts.
So as generation speeds increase from weeks to minutes, how will the traditionally slow, rigid frameworks of defamation law adapt?
It's a great question. Will the sheer volume and speed of modern media force the legal system to broaden its understanding of hyperbole and context in the digital age?
Will courts accept that audiences are smart enough to recognize a metaphor moving at the speed of the internet?
Or, alternatively, will the constant threat of instant legal demands force all modern media to strip away the color, the analogies, and the conversation?
It makes you wonder, if the legal system forces us to put every single brushstroke under a microscope, do we eventually lose the ability to paint the picture at all?